Long Island's manufacturing industry has led the way in building the pieces that have shaped this nation's history. As America's very first suburb, Long Island has long been uniquely positioned to be an industry leader. From Charles Lindbergh's flight to Paris, to winning World War II for the Allies, discovering DNA, and putting a man on the moon, we have seen historic advances in defense, energy, and medical technology. Long Island's innovative spirit has set the pace and helped shape major advances in science and technology. Not only are we smart and skilled, we are a key player in fueling America's largest city and its principal financial engine. Today, Long Island is home to more than 2.8 million residents with over 3,000 manufacturers that employ more than 71,000 men, women, minorities, and veterans, spread across 12 diverse industry sectors. Our success was built by small manufacturers with big dreams. Manufacturers helped to drive New York's economy with $62.68 billion in manufactured goods exports in 2015, and small business comprised 94.2% of all exporters in New York. In the past 12 months, 200 of Long Island manufacturers posted 8,837 jobs. Long Island is home to an amazing array of manufacturers in a variety of industry sectors. Our food and beverage industry boasts 350 companies and nearly 7,000 employees, including Whitson's Culinary, where meals are prepared for customers around the country. The consumer goods industry is alive and well, led by standout company Clear Vision Optical, who creates top-quality eyewear for a worldwide audience. D'Addario in Farmingdale is revolutionizing the music industry one guitar string at a time. Autronic Plastics, a custom plastic injection molding company, is building prototypes and plastic items that make everyday life possible for people here in the U.S. They are one company out of over 350 that employs 17,000 people in their sector. We are also revolutionizing the pharmaceuticals industry, where PL Developments in Westbury is constantly working to create quality health and beauty products for stores throughout the region. The aerospace and defense sector continues to be strong with over 350 companies employing over 12,000 Long Islanders. These firms continue to support the existing defense and commercial aircraft in operation, but are also critically engaged in the production of brand new aircraft. This trend continues to increase year over year, and we have seen an overall rise to Long Island in the commercial tax base, increased home ownership levels, high-tech jobs for women, minorities, and veterans, and more young people choosing Long Island as their preferred destination to live, work, play, and raise a family. Manufacturing on Long Island is growing and will lead the way as America continues to grow and thrive. We believe that working together as one voice, we will make a lasting, generational, and economic impact on this place we call home. We are an integral part of the region's future. We are putting Long Island to work in the jobs of tomorrow. All together, working together, we are the manufacturing industry of Long Island.
Okay, well, good morning, everyone. We're going to just hang tight another couple minutes, let more folks come in and register and get all teed up here. So I'll put us on mute and we'll just hang tight one more minute. Okay, well, good morning, everybody. Thank you for joining us today. I know it's early, but we like to do these meetings early and get you guys in and out the door and get back to work. My name is Patrick Boyle. I'm the Executive Director of IgniteLI. IgniteLI is the manufacturing trade association for all products made here on Long Island. That's Nassau and Suffolk County. We represent companies ranging from pharmaceuticals and nutraceuticals to aerospace and defense to the farmers and growers out on the East End. We get to go up to Albany, down to DC, Nassau County Legislature, Suffolk County Legislature, talking about the wonderful products that are made here on Long Island and the excellent people that are making them. I'd like to introduce you to our panelists this morning, Mr. Michael Harrison from Long Island Business Council, Mr. Tom Cook from Blue Tiger International, Alex Sarkin from Industrial Coverage, and David Mahoney from Silverman Acquampora. I'd like to start with a quick thank you to our board members, Ann Shabunko Moore, President of GSE, Emma Lee, President of ANZ Pharmaceutical, Jordan Finkelstein, President of Exergy, Anthony Acquampora from Silverman Acquampora, Mitchell Reckler, Reckler Equity Partners, and Phil Caniglio from Hofstra University. We also want to take a moment to thank our sponsors, Industrial Coverage Corporation down in Patchogue, Burden LLC, and Jerome Stevens Pharmaceuticals. So about a month ago, New York State legalized recreational cannabis here in New York, and they offered little to no guidance to employers on job site safety and liability concerns. IgniteLI has today gathered a panel of industry experts to discuss the legal, insurance, human resources, and business implications, as well as offer a couple solutions to all of us. So I think we're going to start this morning with Dave Mahoney from Silverman Acquampora. Dave, can you take yourself off mute? And I think you have a couple slides you'd like to share, right?
I do. Thank you very much, Patrick. I appreciate the opportunity to talk this morning. Obviously, this is it's a major development for the Long Island manufacturing community, which I believe stands in the unique place of having a highly skilled workforce that is not only responsible for so many of our nation's products, from everything from foods all the way to defense products. And there's a lot of legitimate concern about how the legalization of recreational marijuana is going to affect and impact the Long Island manufacturing workforce. So today we're going to talk about the new law, how that law interacts with existing federal and New York City laws, and how our Long Island manufacturing community can cope with these changes. Pat, can you just confirm that you can now see my screen? Okay. Okay, so to begin with, we're here talking today because New York State has enacted a new law legalizing recreational cannabis and marijuana. It's called the New York State Cannabis, Marijuana Regulation and Taxation Act. We're going to discuss how it interacts with federal law, the New York City law, and also certain considerations that Long Island employers will have to remember when dealing with reasonable accommodations and individuals with disabilities under the Americans with Disabilities Act. Let's start from the basic premise that marijuana is now substantially similar to alcohol in the way that it's treated under the law and the way that it's going to be treated in the workplace. Alcohol is legal, but an employee can never report to work drunk or drink on the job. So although recreational marijuana is now legal and there's been expanses on the legality of medical marijuana, an employee can still not report to work high or under the influence of marijuana, nor can that employee consume marijuana, ingest it, smoke it, or otherwise get high during the workday. So from the most basic premise, think of marijuana as you would alcohol. Can people do it out? Can people use it outside of work hours? Yes, they now can, but that doesn't mean that they have any right to take those substances during the workday. On March 31st, 2021, the state law was passed. It did several things. It established an Office of Cannabis Management that's going to be somewhat similar to the Alcohol Beverage Control Division. It expands New York's existing medical marijuana program. It outlines adult use of cannabis and possession and growth of the plants. It provides for tax revenue, traffic safety regulations, and provides municipalities throughout the state with an opportunity to opt out of allowing retail establishments inside their borders. It does not allow municipalities, however, to opt out of the legalization of personal use possession. The law expunges certain records and makes criminal justice reform changes to the legality and the consequences of carrying certain different amounts of marijuana. And this is going to affect our criminal justice system and also what constitutes probable cause for stops on other types of offenses. Most importantly for today, it limits pre-employment and random drug testing in the workplace. So now that we've discussed what that state law does, let's also talk about the limitations of the state law. What it does not do is change the fact that marijuana remains illegal under federal law. It remains a controlled substance. And for federal law purposes, the state law does nothing to change, affect, or alter the federal law. So many of the members of IgniteLI operate under federal contracts. Sometimes those contracts are directly one-to-one with the government. Other times our members are subcontractors who service federal contractors. All parties, all businesses that do business with the federal government or with businesses that serve the federal government are still governed by federal law, and they're still governed by the Drug-Free Workplace Act. This means that those employers still have obligations to post drug-free workplace policies and take action when those policies are violated. And they also have to notify contractors of employee convictions. Employees also have obligations to report convictions for drug-related offenses within 5 days to their employer. The long story short is that if your company still operates under the Drug-Free Workplace Act, those obligations have not been affected by state law, and you are still required to maintain a drug-free workplace. The other interaction we're going to see with federal law relates to the Department of Transportation regulations and commercial driver's licenses. This is, I think, one of the most important takeaways of today's talk, is that legalized marijuana does not affect jobs where we have legitimate safety concerns. So when we think about whether or not legalized marijuana is available to your employees and whether or not you can take action if they are using recreational marijuana off hours, we want to take a close look at what those people do for a living, what their essential job functions are, and whether or not there are safety implications associated with their positions. Under federal law, the Department of Transportation has identified bus drivers, truck drivers, train engineers, subway operators, and both airline pilots and ship captains as those with jobs that have such safety implications and such responsibility associated with them that it's absolutely impermissible for those people to use marijuana, either recreationally or medically. All of those jobs are subjected to a drug test called the 5-panel test. It checks for opiates, PCP, cocaine, amphetamines, and THC, which is the psychedelic or the mind-altering substance in cannabis or marijuana. DOT regulated employers, so anyone you employ with with commercial driver's licenses or otherwise operating heavy machinery must comply with all applicable DOT training and testing requirements. And I have to emphasize, all of those companies remain under a zero tolerance policy, even for medical marijuana. So we will talk later about reasonable accommodations under the Americans with Disabilities Act. Keep in mind when we do so that those companies operating under DOT regulations have a legitimate business interest in protecting their status under those regulations and can and should maintain zero tolerance policies. So now that we've addressed the federal law, let's talk about what the state law does and what it doesn't do, more importantly. It does not allow workplace use or possession. All workplace use and possession can and should still be prohibited, and companies should update drug and alcohol policies in their employee handbooks to ensure that it's made clear that the company has an understanding of the new state law, has considered the new state law, and still maintains a drug-free workplace and drug-free environment and a zero tolerance policy. When we talk about workplace impairment, we need to be prepared to look for the indicia that somebody is appearing in the workplace under the influence of marijuana. And again, those symptoms that we're looking for are not terribly dissimilar from those that we would already be looking for if someone reported to work under the influence of alcohol. We're looking for delayed reactions, poor coordination, stumbling, twitching, red eyes, and the odor of marijuana, all of which we should already understand and know what those indicia look like. But now that recreational marijuana is a reality in New York State, special attention should be paid if you in fact notice somebody demonstrating those symptoms in the workplace and report those symptoms to a supervisor. So looking for those indicia that's important, because under the new New York State law, we can no longer just across the board drug test applicants, job applicants for marijuana, nor can we randomly test current employees for marijuana. So again, the only exception to that is if you're subject to federal governmental regulation, or the use of marijuana in your workplace could create a safety hazard. If we narrow down to New York City's law, the New York City Commission on Human Rights back in May of 2020 amended its rules to add exceptions to the general prohibition on pre-employment testing for THC or marijuana. Generally speaking, you cannot test for marijuana under New York City law even prior to the enactment of the New York State law. However, the Citywide Administrative Services Division published a list of job titles where we can still test for THC because of the safety implications associated with those positions. So when we have a conversation with the Long Island manufacturing community, I recommend that we take a look at what the city defined as safety sensitive jobs and look for the similarities between those positions and the employees that our membership employs on a daily basis. We're looking at construction workers at all levels, inspectors, the people who have to make sure that those individuals are doing their job, but we go beyond that. It's not just construction workers. We're talking about heavy machinery, and I think that's probably the most important place for the manufacturing community to look. We have to make sure that when people do operate machinery, they do so in a manner that's both maintaining safety for themselves as well as for their coworkers, and also making sure that people are of sound mind to operate that machinery in a way that produces products that go into commerce that are reliable and safe. So in addition to heavy machinery, if your employees deal with public utilities, power, electricity, all of those are still covered by zero tolerance. If you have employees that are operating motor vehicles, both company owned or personally owned for business purposes, you can maintain zero tolerance policies for those positions as well. What we're really looking for is to avoid impairment, which would interfere with the employee's ability to take adequate care in the carrying out of their job duties that could pose an immediate risk of death or serious physical harm to other people. The long story short here is that if safety is an issue, zero tolerance remains, the best policy for the Long Island manufacturing community. Are there exceptions to zero tolerance? Is if you are not subject to federal contract, there can be exceptions. The Americans with Disabilities Act provides for employers to engage in an interactive process with employees. And we believe that state courts and the Division of Human Rights is going to interpret the new New York state law as possibly allowing use of marijuana as a reasonable accommodation that would allow people to perform all the necessary functions of their job, as long as that use is not in the workplace and not engaged in during normal work hours. So when we talk about, we now understand what the new law says. So how do we comply with new laws? We need to include a statement on employment applications and postings if applicant drug testing is a requirement. Please keep in mind, don't simply rubber stamp that at the top of every job application or every job posting. Every company that's participating in this call today has different types of workers that do different types of jobs. So if we're going to rely on a safety exception for recreational marijuana use, we have to make sure that the job description associated with that position actually has safety implications and a defensible reason for testing for marijuana. As I said before, we want to update handbook policies to ensure that it shows that we've contemplated and are either maintaining existing policies or changing our policies in light of the new law. We want to train managers how to look for impairment in the workplace. And what we ultimately want to do is ensure that either the new policies you put in place or the policies that we're going to continue to enforce despite the new law are applied objectively and not on a person-by-person basis. You can't make decisions about taking adverse employment actions against individuals based on personality or how much one person is liked compared to another. I'd recommend that we look for objective criteria, and the easiest and most defensible way to do that is either to have a company-wide zero tolerance policy or to enact policies that are specific to different job titles. At the end of the day, the less subjective the criteria, the easier it is to defend. In summary, marijuana is legal here now, and that's in all likelihood not going away. However, marijuana remains illegal under federal law, and certain companies will be able to take advantage of their federal contractor or subcontractor status to maintain zero tolerance and the ability to do pre-employment and random drug testing, both under the Drug-Free Workplace Act and under DOT regulations. Testing both in the city and in the state is now restricted. So take a close look at what your people do, whether safety is implicated, whether the use of heavy machinery, commercial driver's license registration, or any other factor allows you to continue to do that type of testing and look for those types of indicia, because ultimately the more we can maintain a zero tolerance policy, I think that is really in the best interest of the Long Island manufacturing community going forward. And just to finish up, we started with this, I'm going to end with this, because you're going to hear employees say, it's legal, it's legal. What's the problem? It's legal. So is alcohol. But once again, neither alcohol nor marijuana has any place in the workplace, especially for the Long Island manufacturing community. And that cannot be lost. Maintain the safety of your employees and your visitors, and make sure that the quality products that we have been manufacturing continue to maintain that same quality. Thank you very much.
All right, thank you very much, Dave. I thought the most interesting slides you had there were on the exceptions to recreational cannabis and testing as well. Testing was always an open-ended question for me.
Yeah, testing's going to be, I think, one of the points where we see the most litigation and where we're going to see most challenges, because the impression that employees are going to have about what they're entitled to do is going to constantly be at odds with employers who have legitimate business concerns about employing a workforce that is using recreational marijuana.
Sure, thank you. And this is a good time for me to remind all the attendees that if you have any questions, please put them in the chat. I am monitoring the chat as we all speak. Wanted to thank Dave again. Dave, is there a if somebody had any further questions or they'd like to talk to Silverman at Compora about helping them build out an HR policy, how would they get in touch with you?
Sure. So you can just reach out to us at Silverman at Compora. The main line is 516-479-6300. We already work with several members of Ignite Long Island, and the manufacturing community on Long Island is very important to us and holds a very close place to our heart. So we'd be more than happy to help anyone try and navigate through this new law.
Okay, thank you very much.
Patrick, I have a question for David, if I can. Sure. In a lot of the work that we do across the country in HR management, one of the issues has come up regarding the federal oversight referred to as OSHA, meaning the Occupational Safety and Health Administration, and the idea of the safety. So companies that are manufacturing, companies that have warehouses and doing distribution and so forth, which is very dominant in the Long Island profile, The idea of people operating a fork truck or having to move packages and that type of thing. Can you kind of speak to that at all as to how that federal law would interfere or how it would impact these marijuana laws now locally in New York State?
Sure. I think it's a good point. I think it ties right in with what we're saying this morning about safety sensitive jobs. Whether somebody's driving a motor vehicle, operating a piece of manufacturing equipment, or taking materials from point A to point B on a forklift or a high-low, all of those people have to have their wits about them and have to make sure that they're not under the influence of any substance when they're operating that machinery. Because to do so would put their own safety in jeopardy or that of their coworkers. So I think that OSHA provides the manufacturing community with yet another opportunity to take a very hard line about the implication of recreational marijuana use on the safety of a workplace. And I think that every Long Island manufacturer should try and take as hard a line as possible about maintaining their ability to do pre-employment testing, random testing, and look for indicia of use in the workplace. Now, there's going to be challenges to our efforts to maintain such a hard line, but I think that OSHA is a great example. The DOT regulations are another great example, and the Drug-Free Workplace Act is the third example of there's nothing in the New York State law which overrides those laws, regulations, or concerns. And as long as a company can, with a straight face, and that's the reason I'm saying we should do this on a position by position basis. As long as the company can say with a straight face, I can't have somebody who's using marijuana in that position, because to do so would put their safety and the safety of others at risk. I think that companies are going to have justifiable positions with respect to continued testing.
Great, thank you.
Real quick, we had just one more question roll in from Robert Harrison, and it's actually it's a question that was on my mind as well. So, if you build and or ship any kind of product to a federal contractor or subcontractor, are you in the extended group?
So,
I'm sorry. Are you in the exception group? I'm sorry.
Yeah. So, what we're really talking about is subcontractors to federal contractors, and I think that you should take the position that yes, you are. This is yet another example of a justification to maintain that drug-free workplace and to preserve your ability to do pre-employment and random drug testing. The company has the right to try to protect its business relationships with the government and with governmental contractors. So if allowing individuals who are using either medical or recreational marijuana would jeopardize your ability to continue fulfilling those contracts, I believe that's a justification to continue testing.
Very good. Thank you. All right, Dave. Thank you again for your thoughts this morning. We're going to switch over to Mr. Tom Cook from Blue Tiger International.
Great.
Tom, if you can just give us a little bit of description about who you are, what you do, and before you jump into your slides.
I'm with the FBI. I want to know the names of everybody who's on this call.
Very good.
So I run a business called Blue Tiger International. We're management consultants. We focus a lot on international business, supply chain, general management, and the interface with human resources and how it interfaces with all the other facilities within an organization. And though based on here on Long Island, we have offices throughout the United States, and we have a reach that goes into all 50 states here. and our experience with this so far are with states like California and Oregon and California, Washington State that have legalized marijuana a number of years ago, and the experiences that our clients have had in trying to manage their responsibilities, dealing with these local laws. So I have a few slides, so let me pull it up here so that we can get through this. Okay, so first of all, I wanted to say is that, being a member of Ignite and this manufacturing and distribution consortium is a good thing. And it's meetings like this that really bring value to the membership. And hats off to you, Patrick, and your team for putting something like this together, because it's going to be a critical issue. And what we're going to hear is when we go on Channel 12 or news or the Newsday and so forth, we're going to read about companies that have gotten themselves into trouble. And hopefully through events like this, we can minimize that actual occurrence. So it's important to have these things. Let me get this to full screen. It's not cooperating. Okay. So appreciate the fact that the legislation is new, and a lot of the things that David talked about is that while the law has come into place, they haven't really structured in the impact it's going to have and all the legal aspects of this thing. And they've created another, political entity within the New York State structure, the Office of Cannabis Management, and they're going to have oversight over this and try to coordinate all this activity. And appreciate the fact that when you start to legislate a new law and then you add a new entity, you're stepping on the toes of all the other governing agencies in the state, as well as the local agencies and municipalities and in counties and cities and so forth and so forth. So this is going to be a mess for a long time, as it has been in the states of, as example, California, Colorado, Oregon, Washington State, and so forth. So we need to be prepared that there's going to be a lot of discourse as they go through the process of trying to organize exactly the legal precedents that's going to be established. So I have a client that's based in Southern Oregon, and the area of Southern Oregon, which borders the northern part of California, the weather is actually perfect and the conditions for growing marijuana. So there's a tremendous amount of activity in manufacturing marijuana and the distribution from those locations. Besides all the HR issues that David has raised, those legal implications, one of the biggest things, and I already have a client that's on the east end of Long Island who's already experienced in this to some extent, is the loss of warehouse and lower end administrative personnel that are working in other areas and on the east end relative to the growing of farm products, is that because there's a greater revenue opportunity or stream related to the manufacturing, growing, and distribution of marijuana related products, they're actually losing people to that side of the business because there's more revenue there. They can pay their people more and more. So Oregon is a state now that has a very serious problem, which is that the marijuana industry and the hemp industry is dominating the hiring process, and they're doubling the salaries and the compensation and the perks and benefits given to people, pulling them out of the normal workflow in these areas of warehousing, distribution, and administration, and so forth. And I have a client that's out in the East End in the farming business that's already seeing that impact already. So I think we need to be prepared for that issue. As David put out, you need to seriously incorporate into your HR manual all the guidelines. And if you Google anything related to California, both from the state level and also information available at the local municipality levels, there's a tremendous amount of information that's available on how to set up HR manuals and set up guidelines and navigate all these challenges that you have. Appreciate that specifically as it relates to this whole circumstance, is that we have issues that are going to come into play that are going to be localized here specifically to Long Island. And appreciate the fact that we're part of New York State and our proximity to New York City, so that has an impact as well. Being that this is a brand new law relative to having been incorporated in March, there's really no experience out there. There's very few resources. All the people speaking on this panel are resources, and I know that they're all, including myself, are available to the members of Ignite to help them answer some of the questions. But appreciate the fact that there's a government control over this, and it's at the state level, but there's a certain amount of uncertainty with how that control is going to take place. The laws are unclear, okay? The use during work hours, the issue that our clients have in other parts of the country is, as an example, most offices have an area outside their office where their personnel can have a smoke if they want to. One of the problems that has happened in some of the other states is that the sensibility and feeling that, well, if I go have a cigarette, I can also go ahead and smoke some weed at the same time. And obviously that's prohibited, similar to how somebody can't go out and have a drink during that period. But the issue is that obviously people have a tendency to interpret the rules as they see fit. And then how the goods are going to be internally distributed, their availability, are they going to be able to be picked up in the e-commerce mode? Do we have to get registered? Do we have to go to a store? How does it interface with the medical marijuana distribution that's already in place? All those things remain to be seen. So where can I grow it? Where can I consume it? Can I grow my own? Right, is a big question. And there is in the provisions a limited amount that people can grow. Can I bring weed from other states or overseas? When we get into the overseas community, understanding that importing and exporting is under federal control. So the rules apply very differently in that world that we have. And also, as soon as goods cross state borders, you're also now in federal control as well. Is recreational utilization defined? Not really, okay? And will there be workplace restrictions, those that are given out at the state level, and those obviously that would be given out customized to your specific business practice? One of the things that we make as a recommendation, and we've seen other companies do successfully relative to this issue, is one is you need to establish a point person in your organization. And that point person is established, and it could be your HR manager or somebody in your HR group, but generally somebody at the management level who's the person that's going to be able to collect all the information that's out there, be connected to the various resources, and be able to guide your company in how you're going to handle and customize the rules as they start to navigate into, more firm points. You need to establish all the resources that are available. I'm going to list a few to you that you have besides the Ignite organization and the people on this panel. And you need to create an initial policy pretty quickly, but be prepared that you're going to update it in 6-month increments, and probably for as much as 2 or 3 years. You need to be continually upgrading it as this whole marijuana issue starts to gel here in New York State. So I put a couple of guidelines to you that we use ourselves when we're giving out specific advice and counsel. You have the New York Cannabis Laws and Regulations. It's actually a hardcover book that came out in April this year, which is only a month old, by a fellow, Omar Figueroa. He basically has taken all the information that's been available in other states and kind of put it all together. There's a great article called High Times, the Complete Guide to Legal Weed in New York. It's a really great step-by-step thing that outlines all the issues that so far have been raised. Because of the implications of smoking marijuana, particularly in a closed location, you have the Clean Indoor Air Act, okay? Both at a federal level and at a New York State level, you have now access to that information. And then you have the laws and regulations, cannabis in California. I put that in there because California is one of the oldest models of having gone through this experience, so they've matured to some extent. And appreciate the fact that their regulations are reasonably liberal as compared to maybe New York State. They may end up being a little bit more conservative. So with that, I make myself available. On the next slide here, we have contact information at the bottom. So you're welcome to reach out to me. There's no cost or obligations. Because you're an Ignite member, we've agreed with Patrick to provide any advice and counsel initially at no cost.
Well, as always, Tom, thank you for your support of Long Island's manufacturing community, and thank you for your words today. I thought that your resources page was pretty great. Never in my life would I have thought that I'd see you cite a High Times article, but these are indeed unprecedented times. Okay, so seeing no questions in the chat, again, remember, if you have any questions, please shoot them in the chat. I will then jump over to Mr. Michael Harrison from the Long Island Business Council. And I think Mike also prepared a couple slides for us this morning as well.
Yeah, we have that. Tom, you stole my line a little bit, saying you're from the FBI. I was going to say I'm from the NSA, and I already know the names, addresses, and personal habits of all the participants. But Pat, I really want to thank you on behalf of myself and the Long Island Business Council for holding this event on this topic. It's not only timely, but it affects not only manufacturers, but all businesses across Long Island. And we're grateful for your leadership on bringing this forward.
Thanks for joining us.
Sure thing. And I'm going to see if I can get and the share screen it's gone crazy on us. There we go. There are obviously two sides to the coin on the business implications. There are the folks who are going to be going into the business of cannabis production and sales. I'm not going to focus on that primarily because they have their people. They can explain better than I ever could of how they're looking to go about things. I'd rather take it from the standpoint that we at the Business Council are taking it from, which is concerns that existing businesses have. Now, some of those have been addressed already, so I won't belabor those, but we'll see if we can go through it pretty quickly. The biggest concerns that we see are quality control and workplace safety. It's well established that marijuana affects parts of the brain responsible for memory, learning, attention, decision-making, coordination, emotions, and reaction time. And heavy users of marijuana can certainly have short-term problems with attention and memory and learning, which in turn affects relationships and mood. Researchers, unfortunately, don't fully understand the effect that marijuana has on the brain long-term, but we do know that neuroimaging studies have shown that there are differences between brains of marijuana users and non-users, and this certainly can transplant itself from outside of the workplace to inside of the workplace, even if you're not getting high in the workplace. In essence, pot is inconsistent with productivity, and it is certainly incompatible with precision, which is something that is of critical to manufacturers in terms of precision. To get the next one, New York's. I think we've gone too far. We may have lost the slide. The off-duty conduct law. David touched on this and really gave a good overview. So I don't want to go too far. You understand that you cannot dispense discipline except under certain circumstances, as David said. We do have concerns that the articulable symptoms are ambiguous to some degree and can put a business at a disadvantage in terms of disciplining an employee or questioning an employee when they seem to be fitting into the array of symptoms that are listed. In fact, so David, you listed one as not making sense. If we applied that to the state legislature, you know, we'd be bringing legislator after legislator in, with considering some of the things that come out, including the way this piece of legislation happened to come out. So what we hope is that we'll be able to avoid to some degree, avoid the types of litigation that will be coming up by having both the legislature and having Department of Labor and having the Office of Cannabis Management expand on the articulable symptoms and bring some specificity to that if we could. And additionally, there's the issue of testing. And even where you can test, obviously marijuana is different than alcohol, where you can get a blood alcohol level that will give you a threshold as when to take action. With alcohol, you don't necessarily have that with marijuana, which stays in your system at times for quite a while, even when you're not impaired. So the CDC and NIOSH have talked a little bit about moving to impairment testing, in which case they would take these articulable symptoms that you referenced, come up with a tangible array and battery of tests that you could do, and be able to define whether or not somebody might be impaired. So far, they have not taken action on that, but they're in the discussion stage. So we look forward to seeing what comes out of that. The idea is that whatever problems are brought to the workplace by marijuana are only going to increase with the legalization. What you can do is take a look at what the pot lobbyists are saying right now. Basically, they're talking about the idea that now that it's legal, and the stigma is removed, you'll have more people naturally being open to smoking or vaping or edibles than you do now, because there's no stigma and there's no punishment for consuming legally. They also talk about how they hope to bring back former users of cannabis who only stopped because they were not permitted to consume it outside of work hours. If they consumed it outside of work hours and came in and were tested, it would be in their system. They'd be subject to discipline. So those people will come back in the market. So you're going to get more people using cannabis than were using it before. And then you have the cannabis industry, which is going to be highly competitive, a lot of big money behind it. And what you're going to get there is similar to the soda wars, where Coke and Pepsi would go to war with each other. And every time they would do that, Pepsi might make a gain, or Coke might make a gain, but the soda industry in general made a gain, and you had more people drinking soda. You'll get the same phenomenon, I believe, with the cannabis industry. So problems that are caused by cannabis will only grow as we move along. And how we got here, in order to be able to go and try to combat some of the negatives that come with cannabis legalization, really have to know how we got here. This legislation routinely failed in the past, and this year it passed, but it passed in what we could call the political dead of night. While businesses were focused on their absolute survival because of COVID, that's where business attention was focused. It was not focused on what was happening up in Albany. Therefore, and some of the proponents of the legislation were quite aware of that and looked to rush things through because they did not want to get business input and did not want to get, more importantly, business resistance to legalization. As a consequence, the law that was passed was, I have to use the nicer term for it, not well thought out. And so there are going to be consequences, some of them unintended, that we're going to have to deal with going forward from that. It's important to know that there were certain legislatures who have, this has been for years, a very personal agenda for them. So including the sponsor in the Senate. But there are also political agendas. This is an opportunity for certain people of a certain political persuasion to go and curry favor with their constituencies. Not uncommon in Albany, but that's part of what's at play. We also need to know that there were good intentions to some degree involved with this law. There are certainly social justice issues that are very real and need to be addressed, but the response was misguided. Rather than address racial injustice and equal application of justice, the legislature opted for, in some cases, removal of justice. which is only going to increase some of the problems and the amount of usage of cannabis. Those are going to have to be dealt with as we go along. Since it's a political issue, it requires a political response from the business community. And this means right now, coming up with every business organization should come up with their laundry list of grievances, not just those related to cannabis, but any issue that's of importance to them. Because this legislation, though it passed by a fairly large majority, not all of the people who voted for it were thrilled with it in its current form. But this is the bill that was there. This is what was voted on, so this is what was going to pass. Since the business community has to some degree been put back on its heels with having to deal with the fallout from the legislation, those legislators, those who understand that this was perhaps the not most thoughtfully put together piece of legislation, need to be targets to go and try to correct some of the deficiencies. While the ideal might be to repeal and then revisit, that's not going to happen. It's just too big. What has to happen now is an incremental approach to trying to correct some of the unintended consequences of this legislation. And among them really are to try to push for a more expansive view of articulable symptoms that would allow an employer to take action against an employee, to be able to specify some of those so that way it could possibly forego some of the litigation that would come as a result of an attempt to take action. There needs to be a push because in New York, as Senator Kruger, the sponsor of the legislation, said, now people will be able to use cannabis. They'll be able to smoke marijuana anywhere that they can smoke cigarettes or vape. Now, if you're a business in a downtown situation, that can be a problem. If you have people walking by who are smoking pot, who have that pot smell attached to them, that is going to possibly shoo away some people from downtown shopping. And if you would just picture a downtown where you have a restaurant with outdoor seating, and half a block down, you have public benches where you have people who can legally smoke pot, that can have an impact on the patronage of that particular restaurant, where people who just don't want to be around the smell of pot. Fortunately, localities, it's not the counties, but villages, cities, and towns are permitted to come up with restrictive ordinances that would prohibit the use, not of marijuana per se, but of all smoking or vaping in certain spots in downtown areas, park, as long as the locality does not effectively prohibit the smoking of marijuana in its entirety. They do have the ability to restrict smoking and vaping, and we would hope that we can push some of the localities to do exactly that. The localities also have the ability to opt out of certain cannabis retail and some of these social consumption sites that are going to be looking to be set up. We would hope that some of the towns and the villages will do that, although the state has seen fit to effectively bribe them to not do that in terms of sharing of tax revenues. Where testing might exist, whether it's drug testing per se, or whether it's the impairment testing that the CDC and NIOSH are talking about, we would hope that the legislature can provide a safe harbor of some sort that would, again, prohibit litigation except in cases of harassment or extreme negligence. And we also need to start to work with industry and government to develop impairment testing standards. And what really needs to happen right now for businesses that want to see change to the cannabis legislation is to form alliances with groups such in law enforcement, with parent groups such as MAD, student groups such as SAD, who have concerns that the increase in cannabis use is going to create safety issues in other walks of life, to be able to get together with them, speak with one voice, go back to our elected officials and say, we need your help. This law is going to have serious consequences for us that you did not intend. Let's preempt those now rather than wait until we have to suffer real consequences in the marketplace. With that, I tried to go through this quickly as possible, so I skipped around a bit, but I think that gives you the gist. And once again, thank you very much, Pat, for doing this and inviting us to participate.
Thanks, Mike. And real quick, I just wanted to ask you to tell us a little bit about the Long Island Business Council, what you guys do, and if you have any events coming up.
Sure. We have no events coming up right now, although we will be releasing, for those who are interested in retail, fairly substantial report on the both the national and regional retail industry that will probably be released next week. As far as the Business Council itself, we're sort of the free safety of the business advocacy groups. We try to look where groups such as Ignite or the Long Island Association might not have their focus at any particular time because there are other pressing issues, and we try to jump into those areas here or there and be able to provide some support and some shotgun ridership to the other business organizations on Long Island. And when we do have an event, we certainly invite you to participate. No cost to join, and be happy to have you.
Well, thank you very much, and thank you for all that you do for business here in Long Island. Okay, finally, we have Alex Sarkin from Industrial Coverage. Alex is a very good friend of manufacturing here in Long Island, great supporter of IgniteLI. I want to thank him for being here and being the caboose on this presentation.
Thanks, Pat, and thank you for organizing this morning. So far, great discussion here from the other panelists. So as Pat said, my name is Alex Sarkin. I'm a risk management consultant with Industrial Coverage. For those of you who might not know, we're a third generation family run independent insurance agency based in Patchogue. And one of our specialties is manufacturing. And we, along with our one of our insurance carrier partners, CNA, are proud sponsors of Ignite. So just wanted to run through a couple of the insurance considerations for cannabis in the workplace. Obviously, it's still very new. David ran through a lot of the legal implications. So certainly not gonna get into that territory, but just a couple things for you guys to keep an eye on, and I will keep this brief. I know we're running a little bit long here. So first off was employment practices liability insurance, or as many of you probably hear it referred to as EPLI. So this particular line of insurance covers suits arising out of wrongful termination, discrimination, and harassment. So I think, as we start to kind of see, cannabis in the workplace become, more prevalent, and, when employers have to take action because they either suspect or, it's deemed that they're, that an employee tests positive and they need to take, some kind of corrective action. Whether it's use in the workplace or recreationally, and they're then sued for that action. That's what EPLI would intend to cover. So as we as the suits start to come in, and we get a better feel for kind of how those are going to be handled. You just want to make sure that you have an EPLI policy in place. It's not, it's not standard on your commercial general liability policies, this standalone coverage. So we want to make sure that you have that policy, that it's covering, all your entities, your employees, and written accurately. And you want to make sure that there's no exclusions or limitations. Insurance companies, as as time passes and cases start to roll in, could they look to limit or exclude certain certain events and suits in this area? It's possible. So we just want to make sure that that you keep an eye on that, and that that there aren't any exclusions or limitations on suits relating to cannabis in the workplace. The next topic I wanted to just touch on quickly was workers' compensation. So obviously everyone has to have workers' compensation, and we just want to keep an eye on how the comp board starts to rule when as the number of injuries and claims starts to rise, as more people are smoking marijuana and possibly being as it starts to kind of seep into the workplace more. So an employee gets hurt, and then there's a drug test done after the injury. They test positive for marijuana. How is that treated? Is it as Michael was discussing, we need to there needs to be some improvements around testing and to determine if they were using it recreationally, and it wasn't a factor in the injury in the workplace, or whether that's too hard to determine. The comp board is generally pretty worker friendly in New York, so just kind of want to keep an eye on that. Discuss with your agent, and your attorney to see how those cases are being decided, and how those judgments are being handled. Another thing that David touched on that that I did want to mention was your commercial auto policy. I know David touched on the federal laws governing the Department of Transportation, and specifically for a CDL, commercial driver's license, which is needed for vehicles that are over 26,000 pounds in weight. So if you do have a fleet of vehicles, or even just one vehicle that requires that CDL, and it's your employee that's driving the vehicle gets into an accident or violates, there's a DOT violation, that can significantly impact the availability of insurance for your business, and as well as pricing. So that's certainly something that we want to keep an eye on. And then to kind of wrap things up here, as obviously we're it's a manufacturing organization, and if you guys if you or peers are starting to manufacture any kind of cannabis products, there are specific programs and specialized coverages for those for those kinds of operations that we do have access to, that we have worked with in other states to help manufacturers in the cannabis business to get themselves properly covered. So with that, I think as several of the other panelists have mentioned, alcohol is legal, but you can't show up to work drunk, and really same goes for marijuana. So thank you, Pat, for organizing this. Thank you to the other panelists. I think great conversation. I certainly learned a lot from you all this morning. So with that, if there are any questions, happy to answer them. But thanks, Pat, again for putting this all together.
Yeah, of course. And thank you, Alex, for again being such a wonderful sponsor and friend to manufacturing here on Long Island. We had a question from actually Sharon Murphy has her hand up, so I'm going to click the button here to allow her to talk. Hey Sharon, if you have a question, you can ask it now. You are on mute.
I think I hit that by accident. I'm sorry.
Okay, no worries at all. Thanks for being here, Sharon.
Thank you.
Okay, So with that, if there are no other questions, I'm going to start to wrap this up here. I want to thank all the. Oh, Michael, I think, do you have a question there? You're on mute again. Mike, you're on mute. There you
Something
go.
that popped into my head when David was talking before, and it's oddball, but in terms of federal contracting rules and the idea that this wouldn't happen in the current administration because they'd be sympathetic to what's here, but with changes in administrations and living in a world of executive orders, what happens if there was an executive order that went out that basically said we want all small businesses, all businesses to be able to be federal contractors. Therefore, here's the new registration process to be an eligible federal contractor. Pay $100, fill out the application. But in order to be eligible to apply and to be in this category, you must have zero tolerance. You must drug test. Would that stand litigation? Would that in effect make everyone a quasi potential federal contractor that had to comply with the federal edict?
That's a difficult hypothetical because it probably, as you said, wouldn't happen for at least 3.5 years, and we don't really know how this law is going to be interpreted and enforced even over the next 3 months. I think that, I think Tom mentioned at the beginning of this presentation, we just don't know what the future is going to hold. I think that certainly the state would look at that type of executive order as an effort to do an end around state law, and as an effort to frustrate New York State's ability to govern its own citizens, and to provide its citizens with certain freedoms that the legislature has deemed appropriate, and so on. So I think that, is it possible that happens down the road? It's certainly possible. As you said, I don't think it happens for at least the next 3.5 years. And I think we'll also see over that period of time a lot of discussion, especially when it comes time for campaign season again, about what every candidate's position on recreational marijuana is going to be. The more states that legalize marijuana, I think that this will become one of the central issues of the next cycle of federal elections. So I think that the Division of Human Rights is going to actively try to enforce the New York State law, and to provide people with the protection that the legislature tried to, or has given them. And I think it's going to end up being a battle, but one that probably isn't even properly framed yet.
Thanks.
Cool. Okay, I saw that Alex actually just answered a question here. But yeah, so I just wanted to thank everyone for being here. We have a couple events that are going to be coming up, and you'll start to see ads for those. We're going to do a foreign trade zone import, export, and cost savings for manufacturers with the Town of Islip Foreign Trade Zone and Mr. Tom Cook. That's still in the works right now. When we're ready to roll it out, we'll be sending out an email blast. We're also going to do an opportunities for businesses in cannabis. Alex brought it up a couple minutes ago, but listen, both sides of this argument, there's going to be wonderful opportunities for companies to grow and to distribute and to distill and to make all the supply chain products for this, pun intended, budding industry. And then finally, we have our IgniteLI golf outing in July. You all should have received a save the date. If not, please let me know. Certainly, we'd love to see you all there. So at this point, I just want to again thank all of our panelists: Dave Mahoney, Silverman, Acampora, Tom Cook, Blue Tiger International, Michael Harrison, Long Island Business Council, and Alex Sarkin, Risk Management Executive from Industrial Coverage. Wanted to thank our sponsors again, of course, Industrial Coverage, Burden LLP, Jerome Stevens, and then our board members, Ann Shabunko Moore from GSE, Emma Lee from ANZ, Jordan Finkelstein from Exergy, Anthony Acampora from Silverman Acampora, Mitchell Reckler Equity Partners, and Phil Caniglio from Hofstra. At that, we're gonna end this panel. If you have any follow-up questions, please shoot me an email, patrick.boyle@ignitelongisland.org.